Imagine the heavy wooden doors of an English courtroom in the late 18th century creaking open, the air thick with anticipation, the scent of sweat, damp wool coats, and spilled ale clinging to the crowd. People jostle for space on the benches, gentlemen in powdered wigs leaning forward with mock solemnity, common folk craning their necks to catch a glimpse, and newspaper men sharpening their pencils. At the centre of it all stands not a murderer or a thief, but a husband. His crime is not
against the crown, but against his own dignity. His wife has been unfaithful, and he has dragged her lover before the courts to answer for it. This was not a criminal trial in the sense we understand today, but a peculiar relic of English law, known as an action for criminal conversation. Despite its ominous name, no blood had been spilled, no theft committed. The phrase was simply a polite, legalistic way of saying adultery. Yet the spectacle of these trials would grip the imagination
the public for more than a century, blending scandal, theatre, and the rigid hierarchies of marriage into a performance as bizarre and revealing as the wife sales that played out in taverns and markets. The origins of criminal conversation stretched back to the idea of women as property, a theme that underpinned the structure of marriage for centuries. Once a woman married, her legal identity merged with that of her husband. She could not own property, could not sue or be sued, and in many cases, could not even keep the wages she earned. Her body, her labour, and her reputation were legally his. So if another man dared to seduce or sleep with her, the husband could claim that his property had been damaged, his honour sullied, his household disrupted. Rather than seek vengeance with pistols at dawn, he might turn to the courts, demanding compensation in money. The lover became the defendant, the wife reduced to an exhibit, and the husband the injured party seeking restitution. These trials were civil suits, not criminal prosecutions, but they carried all the weight of scandal. From the 1700s through the mid-1800s, they became some of the most notorious events in London society. Newspapers published transcripts, sometimes embellishing them with lurid detail, and the public devoured every word. It was not uncommon for a trial to last hours, with spectators laughing, gasping, and whispering as private letters were read aloud. Servants testified about what they had overheard through keyholes, and bedsheets or trinkets exchanged in love affairs were paraded as evidence. Unlike wife-selling, which unfolded in market squares among the working poor, criminal conversation trials were largely the preserve of the middle and upper classes, those with the money and influence to bring their grievances before the courts. Yet both practices revealed a society wrestling with the same problem: how to end a marriage, or at least to make sense of betrayal, in a system that gave men all the power and women almost none. The most famous cases became citywide sensations. In 1782, Lord Grosvenor sued the Duke of Cumberland, the king's own brother, accusing him of seducing Lady Grosvenor. The courtroom overflowed, with aristocrats pressing against commoners to watch the spectacle. When the jury found in Grosvenor's favour, the damages awarded were staggering: £10,000, an astronomical sum meant to measure not only the Duke's offence, but the scale of the husband's wounded pride. Lesser-known men often sued for smaller amounts, £500 or £1,000, but the principle was the same. A wife's infidelity could be converted into pounds and shillings, a betrayal calculated like a broken contract. The rituals of the trial followed a pattern almost as formulaic as the wife sales in the markets. Servants testified to the familiarities they had witnessed: a gentleman's hand upon a lady's knee during supper, a door locked too long, or the unmistakable creak of bed springs in the silence of the night. Private letters were read aloud, their tender phrases, never meant for public eyes, suddenly broadcast to a hall of jeering strangers. The wife herself rarely spoke. She was present but silent, her voice effectively absent from proceedings that determined her fate. Instead, her reputation was dissected by men, her conduct weighed like goods upon a scale. She was not on trial, yet she was the true subject of judgment, her desires and choices reduced to evidence of a husband's injury. And yet, just as in wife sales, there was often a strange undercurrent of agency and negotiation buried beneath the surface. Some women accepted the arrangement, seeing the trial not as a humiliation but as a chance for a new life. If their husband won damages, he might be more willing to let them live openly with their lover, the social and financial transaction smoothing the way. Others resisted fiercely, refusing to accept the indignity of being paraded as an object of lost property. In rare cases, lovers openly defended themselves, claiming the wife's consent, mocking the husband's neglect, and transforming the trial into a contest of masculine pride. The public, meanwhile, rarely sided with the woman herself. They treated the affair as entertainment, gossip to be savoured over coffee houses and tavern counters. Like wife-selling, these trials could end in bitterness, comedy, or tragedy. In 1796, the case of Delaval v. Ainsworth shocked audiences when evidence revealed the wife had been essentially groomed as a child by her much older husband. The trial opening a window onto practices many preferred not to see. In another case, a husband won damages against a wealthy merchant, only to gamble the money away within months, leaving both himself and his wife destitute. Sometimes the damages were token, more symbolic than financial, signalling not so much the ruin of a man's household as the erosion of his pride, and sometimes the verdicts enraged audiences. In 1809, a husband notorious for his own infidelities was nevertheless awarded thousands of pounds when his wife strayed. The hypocrisy of the law, permitting men but never women to sue for adultery, was plain to see, but it remained unchallenged for decades. By the 1830s and 1840s, the atmosphere around criminal conversation began to shift. The same reforming spirit that condemned wife-selling as crude and disgraceful also began to cast doubt on the justice of adultery trials. Women's voices, still faint, began to emerge in the growing discourse on rights and property. The Matrimonial Causes Act of 1857, the same law that began to make divorce more accessible, also eroded the ground beneath criminal conversation. The law now provided more direct means of dissolving a marriage, reducing the need for these public spectacles of humiliation. Yet even into the mid-19th century, echoes of the practice lingered. What made these trials so compelling to contemporaries, and so revealing to us today, was their strange dual nature. On one hand, they were about the law, about damages, contracts, and the rigid rules of property that bound men and women together. On the other, they were about performance. Just as a wife sale in a marketplace was a ritualized act signaling the end of a union, so too was a criminal conversation trial, a public drama, a staged reckoning that allowed private grievances to be aired in front of an audience. Both were responses to a society that offered few legal paths to closure. Both transformed the end of a marriage into a kind of theatre. Imagine then the silence in the courtroom when the verdict was read, the jury foreman rising, the figures pronounced £2,000, or perhaps only £50, the husband nodding gravely, the lover pale and tight-lipped, the wife silent still. Outside, the crowd erupts, gossip spreading like wildfire through the streets of London, to be repeated in broadsheets and caricatures by the next morning. A family is torn apart, a reputation destroyed. Yet for the onlookers, it is entertainment, a morality play confirming their suspicions about passion, power, and betrayal. The system does not heal the wound or restore dignity, but it provides closure of a kind. In this way, criminal conversation trials and wife sales, though so different in setting and style, belong to the same world. They were makeshift solutions to the same dilemma: how to end a union in a society that made such endings almost impossible. They revealed the same truths, that marriage was not only about love or partnership, but about property, reputation, and control. And they exposed the same desperation as men and women, rich and poor alike, sought to navigate laws that rarely bent in their favour. By the dawn of the 20th century, both practices had faded. Divorce law, slowly if imperfectly, began to evolve. Women gained footholds in property rights and custody. The scandals of criminal conversation no longer drew the same fascination, replaced by new forms of gossip and entertainment. Yet the echoes of those crowded courtrooms and noisy markets remain, reminders of the lengths to which people once went in pursuit of freedom, dignity, or simply escape. Beneath the wigs and the halters, beneath the legal fictions and the beer mugs, were men and women struggling against the boundaries of their world, improvising strange rituals of ending where the law had given them none.